Meaning of jurisprudence. The word jurisprudence is derived from the Latin term jurisprudentia, where juris refers to law and prudentia means study, knowledge or skill. Etymologically, jurisprudence is knowledge of law and skill in law. Jurisprudence is a study, knowledge, and skill of law. Jurisprudence is a philosophy and science of law. It is a study of both the theoretical and practical aspects of the law. Jurisprudence is a legal theory which refers to the systematic investigation into law, principles of law, and legal system. Jurisprudence is a foundation of law and picture of law. Jurisprudence is considered as a grammar of law and legal life. Meaning of jurisprudence. Jurisprudence refers to philosophy of law, natural law school, science of law, positive law school, legal theory. General principles of law. Systematic study of law and legal system. Analysis of principles of law and theories of law. It is all about an application, interpretation and perspectives on law and legal system. Jurisprudence governs these three major issues: legal reasoning, legal institution, legal system. Major components of jurisprudence. Jurisprudence is a philosophy and science. Jurisprudence is study about law and legal system. Jurisprudence is an analysis, examination, synthesis, classification of law and legal materials. Jurisprudence is a systematic study of the purpose, functions, kinds, structure, trends, substantive, and procedural aspects of law. It is a source of law and justice. Meaning of jurisprudence. Meaning of jurisprudence. Meaning of jurisprudence. The notion of jurisprudence is as old as human civilization. Jurisprudence is concerned with law, legal system, justice system, and justice delivery mechanism of the society. The concept of law and justice is emanated from the jurisprudence. The concept of law, the various school of thoughts, perspectives and trends are developed in jurisprudence in the globalized world. Schools and trends of jurisprudence. Major 6 schools. Natural law school, historical law school, analytical law school, positive law, sociological law school, socialist law school, realist law school. Trends of jurisprudence. Critical legal studies, CLS, and critical race theory, CRT. Feminism. Postmodernism. Definition. Ulpian jurisprudence is the concept of things, divine and human, knowledge of the just and unjust. Cicero jurisprudence is the philosophical aspect of knowledge of law. G. W. Peyton jurisprudence is a particular method of study not of a law of one country, but the general notion of law itself. Dr. M. J. Sethna jurisprudence is the study of fundamental legal principles including their philosophical, historical and sociological basis and analysis of legal concept. Definition. Holland jurisprudence deals with human relation which are governed by the rules of law rather than with the material rules themselves. It is a formal science of those relations of mankind which are generally recognized as having legal consequences, the formal science of positive law. Salmon jurisprudence is the name given to a certain type of investigation into law, an investigation of an abstract general and theoretical nature which seeks to lay bare the essential principles of law and legal system. John Austin jurisprudence is the philosophy of positive law. In sum, we can say that jurisprudence is a science of law and legal system. It has connection with other disciplines of the society such as in ethics, philosophy, psychology, economy, sociology, anthropology, and politics. Kinds of jurisprudence. According to John Austin, general jurisprudence, natural school / it is universally applicable. Particular jurisprudence, it analyzed to the particular school of jurisprudence in subject of law such as law of person, obligation, property, criminal jurisprudence, commercial jurisprudence, communication jurisprudence, etc. According to Bentham, sensorial jurisprudence, it refers to ought to be. The concept of ought to be is related to natural or law of morality. Expositorial jurisprudence, it refers to is to be. The concept of is to be is related to positive law, posited law. Positive law is written law on the law which is laid down by sovereign authority. Scope and importance of jurisprudence. Scope of jurisprudence is from the human society to outer space. 3 organs of the state: executive, judiciary, and legislature. Relationship between law and society. Speedy delivery of qualitative justice. Analysis of substantive and procedural aspects of law. It is only in comparatively recent times that legal education has established itself as an acknowledged discipline in English universities. Law was previously taught under an apprenticeship system, whereby knowledge of the law was picked up in the course of legal practice without any systematic instruction. An academic tradition, as against training by apprenticeship, is more likely to inspire more philosophical attitudes and less impatience with mere theory. Jurisprudence without pausing to explore or speculate upon these issues. What the law was about. 2. What was or should be the role of the law and the lawyer in society. 3. Whether it was capable of responding to contemporary needs. Scope and importance of jurisprudence. Freund's view was that legal education needs to teach both law and its context, social, political, historical, and theoretical. Every aspect of the legal system try to analyze, the legislative and judicial process. 2. The working of the legal profession. 3. The nature and functioning of law. Jurisprudence involves the study of general theoretical questions about the nature of laws and legal systems. 2. About the relationship of law to justice and morality. And 3. About the social nature of law. Scope and importance of jurisprudence. Jurisprudence involves the study of general theoretical questions about the nature of laws and legal systems. 2. The relationship of law to justice and morality. And 3. The social nature of law. A proper discussion of questions such as these involves understanding and use of philosophical and 2. Sociological theories and 3. Findings in their application to law. A study of jurisprudence should encourage the student to question assumptions and 2. To develop a wider understanding of the nature and working of law. Questions of theory constantly spring up in legal practice. The German case depriving a German Jewish refugee of nationality through a decree during Nazi rule. The English court had to decide whether he was deprived of German nationality. The House of Lords accordingly felt itself bound to hold that Oppenheimer had lost his German citizenship in 1949, the date of German basic law, since he never applied for renaturalization. Oppenheimer v. Cattermole. Nature of jurisprudence. Nature. Jurisprudence is dynamic and developing subject. It is universal in nature. It is an abstract, general and theoretical nature, investigation of essential principles of law and legal system. Substantive and practical value, procedural aspects of law, internationally applicable. Multidisciplinary and interdisciplinary subject. Importance of jurisprudence. Importance. To dispense justice. Analysis of legal concepts such as rights, duties, person, property, possession, and ownership. To understand the concept of law and justice to judges, scholar of law, lawyer, government attorney and student of law and citizen as well. To maintain law and order. To maintain law and order. To ensure rule of law and equality. Separation of power and check and balances. Supremacy of law, equality before law, equal protection of law equals rule of law. Educational value. Social function of law.